My name is Lindsay Olivarez. I'm one of the family law attorneys here at Udall Shumway. Oftentimes when you receive your initial orders in a dissolution, legal separation, or paternity case, those initial orders will contain orders for child support. It can be substantial or it could be a $0 order, but in any event, the court will have provided something by the way of child support for the common minor children. Over time, the need to change that child support order may arise. Changes to income, addition of new children, changes in health insurance, things of that nature will commonly trigger a change in child support. Now, when I say trigger, the triggering event is actually someone filing a petition to change the child support. No one else externally monitors particularly your need to modify child support unless you are working with the state 4D agency. I'm going to focus on private child support modification today. There's usually two ways to do this. First is called Simplified Procedure, and it is what it says. It's a very simple way of modifying child support. A petition is established and then filed and served, and attached to that petition is a child support worksheet which sets forth the petitioning party's position with respect to everyone's income, any daycare expenses, health care expenses, things of that nature. That document is then filed and served upon the other party, and if the other party does not file a response or what's called a request for hearing within 20 days of being served, assuming they were served in Arizona, or 30 days if they were served outside of Arizona, then the court will automatically establish that petition amount of child support as the new child support order. If you have a disagreement with the amount that's petitioned in the actual modification petition, you must file a request for hearing. Then a commissioner will generally hear the matter after the parties have an opportunity to attend a conference with a conference officer. The conference and the short evidentiary hearing happen on the same day, and everything is done very quickly. It's very important that you gather the paperwork that's requested of you, and it's also very important to consult with an attorney before heading to that conference or evidentiary hearing. The other way to do this is by a full-blown petition for modification of child support, and generally that's where you're going to be asking for something other than a change to child support as well. Often this manifests as a petition for modification of parenting time and child support. Since parenting time affects child support, the two things generally go hand in hand. That's a much more extensive process. It'll look a little bit more like your initiating process when you got your original orders. You'll have to present evidence at an evidentiary hearing, unless the matter settles ahead of time, of course. And you'll be presenting evidence on the child support factors and also the parenting time issues or whatever other adjunct issues are present that caused you to go down this route. This is not the same as the simplified procedure where it's a 20-day turnaround and all of that. This is a much more drawn-out process. If you find yourself either needing to change your child support or on the receiving end of a petition to modify child support, either by simplified process or through a more formal process, you'll want to discuss your options with an attorney right away, especially because you have a short turnaround time on responding to these documents. Again, 20 days if you're served within Arizona, 30 days if you're served outside of Arizona. You're going to want to meet with someone right away.